Good evening. Welcome to this Context of Law event, to be chaired by Honour Deborah Taylor, sometime resident judge at Southwark, sometime treasurer of this inn, and giving them both up to go to even greater jobs, which she's doing now. She will introduce the speakers, and I'm just here to be the slightly bossy disciplinarian. At the end of the session, which Deborah will explain in detail maybe, there will be question and answers, and I'm afraid we require you to ask a question, not to introduce yourself or thank the speakers. We can do that at the end, to ask a question in 30 seconds. That way we get a faster discussion and we make greater use of our excellent speakers. The second thing is the speakers will be tethered like chained Bibles to tables outside immediately afterwards, not allowed to speak to each other. Somebody will bring them a drink, but that means that you, particularly the students, if you wish to. And then the last point is that I'm asked to remind you that their library has prepared a valuable reading list on this interesting, controversial and almost constitutional issue. It's Perverse verdicts.carrd.co. But if you will ask me, I'll give you the reference later. Deborah.
Well, thank you. I hope you can hear me. I'm not sure this microphone's on, is it? Can you hear me at the back? Yes, thank you. Well, welcome to this evening's event in the Social Context of the Law series. This evening we have two very distinguished speakers to discuss the very important and topical topic, perverse not guilty verdicts should remain final. On my left, Master Konrad Schiemann has had a long and illustrious career in the law. He was born in Germany and spent the Second World War being bombed by the British. In 1946 he came to the UK and as an orphan, and he set out his career, his illustrious career in the law, in a memoir, A Dual Perspective, a German and an English judge. Because after that, he went, and after school and Cambridge, he practiced at the bar from 1964, becoming a Queen's Counsel in 1980, a High Court judge in 1986, and a Lord Justice of Appeal in 1995. During his time on the High Court bench and, of course, in the Court of Appeal, he dealt with a number of criminal cases. He was also a judge of the Court of Justice in the European Union between 2004 and 2012, and is an honorary fellow in law at Pembroke College, Cambridge, as well as being a former treasurer of this inn. After a successful career at the criminal bar and being head of chambers in Bristol, Master Peter Blair was appointed as a senior circuit judge and the honorary recorder of Bristol in 2017. He also sits in the Court of Appeal Criminal Division and a deputy High Court judge in the King's Bench Division and in the Administrative Court. And he brings a wealth of experience of all aspects of the criminal justice system and criminal law to our discussion tonight. And so to business. I'll deal with the question and answer session at the end of the two statements which our participants this evening are going to make, but perhaps we should just start with an introduction with a question: what is a perverse verdict? Well, one definition is that it's a verdict of a jury that's either contrary to the judge's direction on a question of law, or totally against the weight of the evidence, or, as in most such cases, both. For some, the jury system is sacrosanct, often described as the cornerstone of criminal justice, and perhaps more romantically, as the light that shows that freedom lives. That's rather out of date, I suspect. But are we as a society content to take perverse verdicts by juries as a necessary component? If we're to maintain the jury system and rule of law in an era of populism and misinformation and trial by social media, should the prosecution have the right to seek leave to review perverse acquittals? That's to say, those where there's a clear direction that on the undisputed facts there's no defence in law. Or are those verdicts an important safeguard of last resort against wrongful imprisonment and government tyranny? Do they assist the development of the law to keep in step with society? Juries are acknowledged as not infallible. And of course, where a jury is shown to have wrongly convicted an accused person, a higher court can overturn that conviction. So should there also be a similar power for perverse acquittals by juries? This, of course, isn't a totally novel concept in crime. If a district judge sitting in a magistrate's court, properly directing himself or herself that there is in law no defence to a charge, but nonetheless decides it's all terribly unfair and acquits the defendant, the Crown Prosecution Service would undoubtedly require the judge to state a case for the opinion of the High Court, which would most likely in turn return the case to the magistrate's court with a direction to convict. So is that a power that should now be open to the Crown, or a similar power where a jury convicts in the face not only of clear evidence, but a direction from the judge that in law there's no defence to the charge? And if not, why not? Do we consider those sort of juries as impregnable because they are verdicts of the people? Never mind the evidence. Can we ever know, absent a reasoned decision by the jury, how the perverse decision was reached? And can we know if the same verdict would have been reached by a different jury, also giving a verdict to the people on the same evidence and directions from the judge? So after that introduction, I'm going to ask Master Peter Blair to speak to us on this subject.
I'm sure at some stage you will have seen a cartoon of a judge in mid-explosion, with their hands held out wide in exclamation, their face as red as a pillar box, eyes bulging, and their wig suspended somewhere in mid-air several inches above their head. And on occasions that might secretly have been a picture of my inward reaction to a jury verdict with which I profoundly disagreed, although on the whole I remain completely indifferent to whatever decisions they choose to reach. In 1960, Mr. Justice Stable got in trouble with the Court of Appeal for this legal direction to a jury. I quote, "In 10 minutes I shall leave this building, and if by that time you have not arrived at a conclusion in this case, you will have to be kept all night, and we will resume at 11:45 tomorrow. I do not know why you should require all this time to talk about the matter. May I suggest that you use your common sense and do not worry about legal quibbles." He was rewarded with a guilty verdict some 6 minutes later, but in due course the Court of Appeal was less impressed. And one wonders whether he was aware, when he was giving that direction, of the trial of the Quaker preacher William Penn and his congregation member William Mead, just 290 years earlier, where their trial judge really did lock up the jury without food for 2 nights, leading to a writ of habeas corpus before Chief Justice Vaughan in the case of Bushell. As I'm sure all will know, the plaque to that event in the Central Criminal Court outside Court 1 records that this established the right of juries to give their verdict according to their convictions, or conscience, as we might now say. The Recorder of London back then, however many years ago it was now, 350 odd years, had directed the jury to convict, but they refused. So he fined them, locked them up until they paid up. And then in the case of Wang in 2005, Lord Bingham gave the House of Lords his view and upheld the proposition that there are no circumstances in which a judge is entitled to direct a jury to return a verdict of guilty. A judge can get pretty close to directing this, but must always add the proviso, the verdict is ultimately a matter for you to decide. And the corollary was upheld by Lord Chief Justice Thomas in Goncalves, where he said a jury acquittal cannot be questioned. Now, a juror takes an oath to try the defendant and give a true verdict according to the evidence. And since we're not permitted to know what happens in the jury deliberations, and they give us no reasons for their verdicts, we usually have no way of knowing if they have been true to their jury act, oath, or affirmation. And so we have this tension between the obligation to give a true verdict according to the evidence and their right to give their verdict according to their conscience. Can you, as a barrister, address the jury and invite them to vote according to their conscience, rather than according to the evidence and the legal directions they have been given? Absolutely not. And that led me to having an exploding reaction of the sort I began this discussion with in the trial of the people who pulled down the statue of Edward Colston in Bristol a few years ago. One of the defence barristers had the audacity in his closing speech to invite the jury to reach a verdict which put them, quotes, on the right side of history, at which point explosion occurred. I reprimanded him and expressly directed the jury to ignore such irrelevant pleas and considerations, but to focus instead on the legal defences which the prosecution had to disprove. And there were legal defences, notwithstanding the politicians' protestations when these four were acquitted. So a barrister can't invite a jury to decide a case on considerations beyond law and evidence. What about a member of the public who holds a placard stating no more than what was decided in Bushel's case and holds it in the sight of potential jurors, reminding them of the principle, sometimes known as jury equity? Well, in 2023 and last year, many people were doing just that outside Crown Courts up and down the land, because the Solicitor General sought to bring contempt of court proceedings against Mrs. Warner for doing just that outside Inner London Crown Court during an Insulate Britain protest trial. And Mr. Justice Saini, a year ago, March last year, refused permission to bring proceedings against her because she hadn't interfered with the jurors. She had done no more than inform passers-by of the principle of jury equity. She'd not been inaccurate in what she'd said, and there had not been a serious risk of interference with justice. Although there was an initial plan to appeal against his judgment, the new government, when it came in, chose not to. So where I think I disagree with our presiding judge on the Western Circuit, Mr. Justice Saini, a little, is whether in reality the principle of jury equity that we're speaking of should be regarded as a power but not a right. Now, I'm no constitutional expert, but I think in simplistic terms the King has a power to refuse to sign new legislation into law, but he doesn't have the right to do so under our constitutional monarchy. So is it perhaps not true to say that a jury has this power, but it's an old anachronistic power which there is no rightful justification to exercise in modern times? We do not have a tyrannical state which demands the pressure valve of a perverse verdict to exist as a jury right. But however one puts it, maybe all this legal language and subtle distinctions between power and right ultimately become somewhat meaningless because a jury will do what it wants. Because of that, I suspect in the case of Catherine Gunn, who was that person working at GCHQ in 2003 and leaked memos showing that we were spying and the US were on other UN delegates before deciding whether there would be another resolution in favour of an Iraq war, which Keira Knightley played so beautifully in 2019 in the film Official Secrets. That case was pulled just before the trial was to commence. The same period of history when I was asked to prosecute saboteurs of the US Air Force Base at Fairford in Gloucester in those days preceding the Second Iraq War. I think I'm permitted to at least relate this of my advice. I advised the MOD police that I was pessimistic that we would find a jury of 12 people who would convict when B-52 bombers had dropped cluster bombs on Baghdad and depleted uranium bunker buster shells in that city. The MOD D decided they were going to proceed. Nonetheless, it went all the way up to the House of Lords on a preliminary question of whether they could run the defence of preventing what they believed were war crimes. And at trial, I was proved right. Not a single one of the 3 jury trials was able to reach a verdict on which at least 10 were agreed. In the retrials, 2 ended up in acquittals, the third a conviction, which was fairly inevitable seeing they'd videoed themselves admitting the offence, and a predecessor as Recorder of Bristol gave them conditional discharges. So, juries will be juries, perhaps whatever the lawyers say, and whatever the politicians would like. Discuss. Thank you.
Thank you. I'm going to ask Konrad. I think you would prefer to do that sitting.
Yes, do you mind? I come at this from a rather different angle, I think, as to how we organise our society. And I think it would be generally agreed that Parliament makes the law and the function of the courts is to apply it. And Parliament can, broadly speaking, make any law that it likes. And Parliament can say, this is a question to be evaluated by the jury which tries the person. Or Parliament can say, this consideration, namely that it is in the public good that the earth should continue to live and not be despoiled by further digging of coal, this is a matter which should be decided by Parliament, not by the jury. But the Parliament could say the jury should decide it. But that's the way we run our country, and that seems to me to be broadly a good idea. And when the case is tried, sometimes it is tried before a district court, sometimes it is tried before a Crown Court with a jury. And it doesn't seem to me that the answer of what is a lawful verdict can depend on who is doing the deciding. If we're going to try and look abroad, as it were, put yourself away from the traditions in England, you'll see that the function of the court is to apply the law. And I think one would generally agree that it is an unhappy state if the law is misapplied, that should be the final word. Now, I draw a distinction between what should be done to the jury and what should be done with the verdict. I have no problem at all with not putting pressure on the jury, either by depriving them of bread and water, or indeed by giving them some sort of monetary penalty for reaching the wrong verdict. I think that would be a mistake. So that leaves the jury free to come to a decision. But in my view, a proper system of law requires that the decision that they come to should be in accordance with what the law is. And if they come to a different decision, the question then arises, well, what's to be done about that decision? Now, it may very well be that if a jury perversely acquits someone, that in those circumstances, the prosecution decide, well, we'll leave it at that, because there are reasons which kind of motivated them, which may make perfectly good sense to them, and it is not worth prosecuting further. We accept prosecutors have a power to decide not to prosecute in particular cases. But if the prosecution say, no, we've got to establish this principle and it is important, then I see absolutely not the slightest reason why that judgment of the jury should not be capable of being appealed to a higher court to see whether or not it is in accordance with the law. If the higher court decides that it is not in accordance with the law, it may very well be wise for the higher court to send the case back for retrial. And then the prosecution can consider whether indeed there should be a retrial, and they can leave it to the jury. But the jury has no right to ignore these things. It is merely that they are free to do so without being under any personal risk. That seems to me to be perfectly acceptable. And indeed, I have found that when I was trying as a judge, there are times when the jury reached a perverse verdict in the sense of being clearly against the law, when I was delighted that they had done so, because it had removed from me what had been a terribly difficult sentencing problem. The one that I remember most clearly is a case where a man was charged with rape of his wife in circumstances where they had been married for a very long time, and she'd got rather more bored with his sexual activities than he had. And they reached a perfectly amicable agreement that she expected to be left alone, except on Fridays when he could, as we used to say, have his wicked way. And that worked perfectly well for a number of years. But one day he came back having had rather too much to drink and forgot which day of the week it was, and went ahead all the same. And his wife reminded him it was the day of the week, but he didn't seem to take any notice. They turned over, went to sleep. He went off to work the next day. She went to her mother, who said perfectly correctly, if you told him it wasn't Friday, then it's rape. You've got to report it. And so I don't know if that was a wise decision, but she went to the police and did report it. That's her mother. The police then went round to his place of work, arrested him, and took him off to a hostel and forbade him to go home. And the case came on for trial in front of me. And I was rather wondering what on earth one should do. I was a rather inexperienced judge at the time. And I turned to my fellow judges and said, what on earth does one do with this sort of case? And they said, oh, well, the guidance is quite clear. You have to give him at least 3 years. And I said, oh, I'm not going to do that for a piece of boorishness that night. And they said, well, there you are, on your head be it. And so I was rather worried. But I asked to see the visitor's book at the hostel. And I saw, to my surprise, that the wife had visited him every day. And when she gave evidence, she described what had happened, and she wasn't cross-examined by the husband, who said, no, my wife's a very truthful woman. If that's what she said happened, I'm sure that she's absolutely right. I just had too much to drink that night. And I said to the wife, when did you last see your husband, knowing the answer? And she said, oh, well, I saw him yesterday. Oh, was that the first time you'd seen him? Oh, no, I see him every day. Why do you do that? Because I wanted to come home. And at this point, I looked at the jury, and they were sort of casting their eyes up to heaven. And I said, well, what do you want him to happen? What do you want to happen to him? And she said, I want him back home. I then had to instruct the jury as to what the law was, and the law was perfectly clear. And perhaps being false to my judicial oath, I don't know. I read to them the definition of rape and simply said, well, look, you've heard the evidence, and it's been a very short case, and you have to decide whether the husband is guilty of the serious crime of rape or of a serious bad behavior on that particular occasion. And I leave it to you to decide what to do. And they retired and came back after 5 minutes and found him not guilty. Now, I was very relieved. And there have been 1 or 2 other cases like that where one has been spared a bad decision, a difficult decision on sentencing. So I'm quite grateful for juries to do things, and I think it can encourage Parliament to alter the law if they get the impression from a series of judgments by juries about such things as preserving the earth, as to which way they ought to alter the law, if at all. But at the end of the day, I think it is, for a properly civilized society, it is for the Parliament to make the law and set out what the task of the jury is. And the jury should not be regarded as having a right to do that. And to do otherwise, I think, produces a situation of complete uncertainty in the law. It can't be the right way of dealing with a particular set of facts to have an answer given by one jury who has not been chosen for that purpose, and a different answer given by a different jury, and a different answer still given by a judge. That leads to uncertainty, and law ought to be certain. So that's my broad approach to it, really, as a matter of constitutional law. We live together on the basis that we forego our right to make our own decisions in certain fields for the benefits of living in a society where law is clear and regulated. So that's my reaction to that.
Thank you very much. Just to pick up on a couple of points that you both made, perhaps I can just ask you, Peter, do you see the difference between the potential appeal by way of case stated from the magistrates' court if the district judge directs himself correctly but decides to take go off on a frolic of his own, perhaps as the description, and come to a decision which is contrary to his own directions, that can be corrected, whereas a jury properly directed coming to a similar decision, there's no appeal from that?
I think the problem practically in most of those, in that parallel, is knowing what the jury's reasoning is and our inability to find that out. We're all awaiting Brian Levison's proposals about how we're going to cope with the problems in the criminal justice system and the backlogs of trials, and the highly trailed probability that there'll be an intermediate court where a judge will sit possibly with two magistrates, where we will have to give our legal directions and reasoning. And I can't imagine that there'll be anything other than a parallel to the magistrates' appeal by case stated that you've mentioned, so that if we reach a perverse acquittal in the eyes of the prosecutor, they'll be able to appeal by case stated. So I can see how, when you know what the the attempted rationale for the acquittal is, that should be a permitted appeal. But I think there are very few cases where a jury's verdict can't in some way be rationalised by reference to their slightly contrary view of a witness's credibility or whatever.
I think one of those cases, which I think neither of you have mentioned, is Clive Ponting. I don't know whether everybody here remembers that case. Again, it's an official secrets leaking case where it was quite accepted, and I think the evidence was very clear that he had leaked documents, but the jury nonetheless acquitted him. So the question is really whether it's something which does undermine the rule of law and democracy, whilst the jury may think it upholds democracy.
Well, like all these questions, it's a question of who should decide in the last analysis. And I have a feeling that jurors are not the people who are being paid to decide that. In our constitution, it's Parliament who should decide how that sort of approach should be, how that sort of case should be decided. And Parliament can say, this is to be decided by the jury, in which case I have no problem at all. But if Parliament hasn't said that, for the jury to be regarded as having had a right to do this seems to be very odd indeed. But that may be that my continental origins lead me to have a value for intellectual consistency, which is greater than is sensible for ordinary people to have.
I think in the United States, but I may be wrong, a perverse acquittal can in certain instances involve a judge overturning it and saying, well, it's nonsense. But of course, that decision of the judge can and would ordinarily be appealed, and a higher court would decide whether the judge should or shouldn't have intervened. And they do it, I think, more often than not with inconsistent verdicts or their perception that a jury couldn't have acquitted of one count and convicted of another.
I have the feeling that if I was innocent of something, I would rather have a reasoned verdict than simply be told that I was guilty with no possibility of further interrogation. But the practicalities of producing a reasoned verdict from a jury of 12 people who may have had 12 perfectly different reasons for getting to precisely the same answer, I can see is a huge problem. But that is in nature, inherent in the having juries at all.
And in a sense, it's the difficulty with the perverse verdict, that you simply don't know how it's arrived at, who arrived at it, in what proportion, if you like.
Well, if the perversity consists of it being against the law, as opposed to a misappreciation, as you would say, of the evidence, if it's against the law, well, then it doesn't much matter how they came to the conclusion that it was one to be ignored. It's very useful. It may be a useful guide for future action by other people, but it shouldn't decide that case, in my view.
I think perhaps what we'll do now is to take some questions. I know that Master Nice said at the outset that it would be limited in your question to 30 seconds. It's an advocacy exercise as well. Can you ask a question in 30 seconds? And we'll try and answer them in 30 seconds as well. So perhaps we can just have a few questions. I know some are going to come up on the iPad that I have in front of me. Does anybody want to raise a question? Yes.
I'm not sure, Madam Chairman, whether this question is answerable. That is to say...
It's the question, though. That's the real question, if you like.
Not guilty should remain fine. It depends on all the circumstances. For example, does it not? What we normally mean by a perverse not guilty verdict is a verdict that's against all the evidence. And in those circumstances, if new evidence comes along, then I think everybody would say, well, it's sensible that the case should be reconsidered in the light of the new evidence. Now, that's perfectly clear, I think. The trouble is that perverse doesn't necessarily mean, as you pointed out in your opening, against all the evidence. It could be against the law as directed by a judge, for example. Sir Konrad and I were in a case where he was the judge and I was defence counsel.
I'm going to ask you for your question.
Am I? Well,
Thank you.
Yes. It's my answer is it's impossible to generalise over the whole sphere. There are things that are obviously perverse, that is against the evidence, and then it's easier to make the decision. Question, isn't that right?
Yes. Do you agree that it's entirely a question for the circumstances of the case or not? That a perverse verdict?
I think it very often is. I mean, who are the people who squawk the loudest about a perverse acquittal? Obviously, direct victims of crime may well and justifiably feel very badly let down. But quite often, and let me be controversial because I like being controversial, it's politicians. And one of the most obvious examples for me recently was that Colson statue case where the politicians went completely mad saying, you know, this verdict is perverse. But not in the traditional sense it wasn't. there were legitimate defences, far-fetched perhaps, but one of which was an honest belief in the consent of the owner. And the owner was the people of Bristol. And the people of Bristol had been campaigning against this statue for nearly 100 years on the basis that it was put up hundreds of years after Colston died by some very rich merchants who wanted to show off. And the generations of people who'd come over from the West Indies and knew his history were incensed that this should be central in Bristol and described as one of the most virtuous ones of our citizens. And so one can easily see that the politicians' fear of a perverse verdict, and everyone will be pulling statues around the country in the centre squares of all our towns and cities, completely misunderstood the long Bristol history of failure by the local council and the political process of achieving a change in the statue's description. And so the context made it very much an appreciable and understandable verdict.
But Peter, presumably you didn't direct them that as a matter of law there was no defence.
I didn't.
No, so
But most politicians, I think, from all one read, just laughed at the defences that had been contrived. And some of them had been contrived, I think it would be fair to describe.
I recollect a case some time ago where a person had helped a spy to escape to Russia, escape from prison to Russia.
Yeah.
And nobody could find out who the person was who helped the chap to escape. And 20 or so years later, the person who'd helped him escape wrote a book in which he described in loving detail how he had done it. And instead of matters being left there, the prosecution thought it right to prosecute him for helping a prisoner to escape. And he was acquitted. No doubt, because the jury thought, well, this is really rather silly. It's now 20 years on. Most countries, albeit not this country, most countries have a rule which says that after X years, you leave a chap in peace and you don't resurrect past misdemeanors. But here we don't have that. But they said, look, this is quite ridiculous now to... I suspect that's what they thought. It's guesswork on my part. It's ridiculous to do anything about it. And so he was acquitted. Now, that was a perverse acquittal by my reasoning, because he effectively admitted having done what was admittedly a crime. But there we are. And it was quite a useful indication, perhaps, as to how people thought things should be dealt with after this length of time. But I don't know that you probably do know, I don't, whether English law is still one which gives no time bar to the sort of major offences. I know there is before magistrates' courts and such like, but the major offences like murder, I think you can be prosecuted with 40 years later. And it's really a very unsatisfactory situation.
I have to say I don't know in that case, and somebody here may know, whether their defence was, well, I was a fantasist and I may have written this book, but...
Oh, no.
And whether the judge directed the jury there was no defence.
I think he did.
Here we are.
Okay, so
Any other hands up?
I've got one, and it's really picking up on the point of there being no defence left to the jury, because we seem to be particularly seeing what may be seen as perverse verdicts in protest cases, where all the defences have been withdrawn from the jury. And of course, the point's been made, well, it's not juries who are paid to decide the law, but we do expect juries to give up their free time to determine matters of law. And in some ways, if these perverse verdicts are almost a moral objection to convicting people by members of the public who may disagree with the laws that are being brought in and may disagree with the prosecution being brought, it is really the only answer to take away these type of cases from juries. And then do we run into the same moral issue that we're effectively withdrawing a particular type of case because there is this concern about perverse verdicts, but those perverse verdicts may be coming from a moral objection towards the approach of Parliament towards, for example, non-violent protest.
So your question is, should we take those sort of cases away from juries, or should we allow juries to make their decision on moral rather than their oath?
I suppose my
basis?
question is, from a case backlog and resource point of view, to avoid the pinging back and forward to the Court of Appeal, who might send it back for a retrial only for a jury to do the same thing, is the answer to have non-jury trials for that category of cases? But then is it wrong to direct non-jury trials for a specific category of case in response to what's perceived to be a problem?
What do you think about that?
I do think it's dangerous to categorise something that you don't like the outcomes. And I think it's also important to bear in mind, and we haven't really said anything very much about it, to get 12 people agreeing is quite a high hurdle. And 12 people agreeing on an acquittal, or maybe 10 to 2. And I think we can bear that in mind and the common sense of the public, and rely on that as at least some curb on ridiculous, very easy, perverse acquittals.
But do you think that getting your 12 people together, those are people who are properly informed? I think I've mentioned misinformation, general sort of lack of mediated news, those sort of aspects. Do you think that people come into this with an open mind?
Well, I think it's hard to get 12 people who don't come with an open mind, but the power of the press is very significant. And in some of those protest cases, I'm sure it's hard when you're representing one side or the other not to feel that the press is affecting outcomes sometimes.
I think I was really more talking about the internet rather than the press.
Yeah. Well, I can't answer that question, I don't think.
Yeah. There's somebody here, yes.
Just to ask the extent to which the panel think, but perhaps whether or not a trial is by jury or not, partly distracts from the question that Northern Ireland has, for many years, not had trial by jury in certain offences, fewer now, but more in the past. And actually, Northern Ireland is certainly not free of contested verdicts one way or the other.
And are you suggesting that it doesn't make any difference whether it's you have a jury or you have a judge alone?
Well, I think Northern Ireland's history is not one anyone would probably want to copy, but that it doesn't. I think, particularly in England and Wales, there's a lot of discussion around juries, whether to continue with that to the extent that it has been, and actually perhaps looking towards a sort of verdict-based analysis. And for instance, rape trials, occasionally hear politicians say perhaps the issue lies somewhere in corroboration and the jury's willingness to perhaps accept excuses and acquit. But actually the evidence from Northern Ireland, as far as I'm aware, doesn't point to the fact that having judges rather than juries particularly led to massively different conviction rates that people might otherwise have thought that you might get.
Have you any views on that? I'm not sure that I know enough about the verdicts and the different types of verdicts in Northern Ireland to say anything about it.
I don't either, but I find it rather an odd legal system, if one can step outside and look at ours from the outside. I find it an odd legal system which says how you treat something depends on what particular body decided it, whether it's lawful or whether it is not. It seems a very odd thing. And now when one has talk, for instance, of a reclassification of things which used to be for jury trials, now no longer for jury trials, suddenly a whole swathe, I exaggerate because I think we're dealing with a very narrow group of cases actually, amongst the totality of criminal cases. But to have that case removed from one group where it is perfectly possible to have a verdict which stands and is regarded as immovable of not guilty, to a group where the only possible verdict is guilty. It's odd. I mean, it shows there's something wrong if the precise classification of who tries a case depends on what can legitimately be done to it or lawfully be done to it.
Thank you. Sorry, I think there's somebody at the back, and then I'll come back to you. Yes.
It's two questions. I hope that's permissible. The first is, could perverse verdicts perhaps be reduced to their lowest level by juries in criminal cases giving special verdicts, as in civil police actions, and general verdicts in criminal matters? But the second more philosophical point is behaviour such as sex offences or domestic violence will amount to a breach of Article 3, particularly if against a woman. And the failure of a court to convict when that is perverse will also amount to a breach of Article 3, which a Strasbourg court wouldn't countenance, or which they would find does amount to a breach. Given that the Human Rights Act itself, at Section 6, says it's unlawful for a public authority, which includes a court, to act in a manner incompatible with a convention right, why should a jury be permitted to return a perverse verdict if that amounts to a breach of Article 3 with respect to the woman or any victim who has had a criminal offence committed against them, when that offence does itself amount to such a breach?
Can I just ask a question in relation to your first question? By a special verdict, what sort of verdict would you suggest a jury might be able to return in a case, for example, of, I'm going to take one of these protest cases where, in fact, we're really talking about that small group of cases largely these days, I think?
Well, the special verdicts, at least in a civil jury action, the jury are asked questions with a yes or no answer. And so they answer the factual questions that are put to them with yes or no. And then the judge will take those factual questions and decide on the facts whether the claimant has proved that there has been a false imprisonment or a malicious prosecution. And one could see the same potentially working in a criminal case where a jury answer yes or no questions to the criminal standard. Then on the basis of those factual questions, the judge could determine whether the criminal offence is or is not made out. And at least it would identify if there has been an error in the jury's reasoning.
What do you think about...
It's an interesting idea, and I haven't heard it expressed before in that way, because, of course, we are giving most juries a document called a route to verdict, which has the questions already drafted that are designed to get the factual answers and then route them through the legal sequence of thinking that's required to reach a verdict of guilty or not guilty. I think it's quite an attractive idea to try and ease out or try and find out what route the jury has taken. I mean, you can infer it in some simple cases, but in others they may have come to different decisions at different steps, but ended up with the same outcome at the end. So I think it requires a lot more thought to deal with that. On the Article 3 point, domestic violence example that you give, again, I've not come across a case of any complainant making a big song and dance about the court having breached their Article 3 rights. I don't know if there's any European Court of Human Rights precedents for that.
As regards route to verdict, I remember very clearly when I was a very new judge, drawing up precisely that sort of a document, showing it to prosecution and defence counsel before handing it to the jury. Both counsel agreed that I should not do this. This was quite impermissible, had never been done before, etc., etc. And I said, why not? And there wasn't a very clear answer. And so I did it all the same. And I'm rather intrigued to hear that this has now become absolutely standard.
It has.
It is absolutely standard.
And it seemed to me to be helpful to say, well, this is the route you should follow. And then at least a higher court can say, well, look, they were sent down the wrong path by this judge.
Well, that's exactly what happens. It is absolutely standard, and the higher courts do say the judge gave wrong directions. Before I come to you, Tracy, can I just ask a further question? That being the case, and you have a written route to verdict, do you think it would make any difference having a special verdict in the sense that the jury would just be asked the same questions and find some way to come to the verdict that they want to come to?
I do actually, because a route to verdict or legal directions the jury are given really are the legal directions, and one doesn't know necessarily either the factual conclusions to which the jury have come on each issue, or even if there is agreement with the jury on that issue. And there are some offences where the Court of Appeal Criminal Division has said that it doesn't matter if jurors don't necessarily agree on the factual elements, as long as they all agree on the final decision. A route to verdict is materially different from asking a jury, say, 10 or 11 questions where they have to give a yes or no answer. Then the judge determines the decision on that. And it would mean the submissions to the jury are different, because if they're only finders of facts rather than finders of law, the way in which they would be addressed by counsel in closing, there'd be less ability to make the types of speeches about being on the right side of history, because they aren't making determinations on matters of law. They're not finders of law. They'd be directed purely to the questions of facts they have to determine. And then one would have a written list of yes or no answers to those, which would identify the factual decisions to which they've come, which you wouldn't get at the moment.
But surely there are some decisions, for instance, is a particular driving negligent? That's not really a question of fact properly so called, which one can say, yes, this is, or yes, this isn't, but involves a certain amount of judgment. And that seems to be reasonable to leave to the jury, doesn't it?
Well, negligence is a legal determination, but you would ask factual questions, and then the judge will take those factual questions and apply the law to those facts in the way that takes place in a civil jury without any difficulty in civil police actions at present.
Thank you. Yes, thank you. And next.
You'll probably hear me without it. But
perhaps nobody else can, though. No. Thank you.
Thank you very much. This is probably just a hypothetical, but it is a hypothetical. I'd like to hear your reflections. I don't think there's an answer. So if it is the function of the court, judges, to interpret the legislation, what I'm suggesting, that has been suggested, that a number of people on current protests are being charged by the CPS under counter-terrorism legislation. Now, I'm probably going to answer the hypothetical. It's probably likely that in due course, because these cases, as we've heard, it's difficult to get rape cases and sexual offences cases on. If these cases are not going to come up for another year, it may be likely that CPS will relook at this. But I mean, the question is, what will happen when it's a matter of protest, a matter of civil liberties question, that they're being charged that they're likely to be charged under counter-terrorism legislation? We'll see. To what extent does the Home Secretary, when we were looking at the whole social context of the law, or those other powers perhaps determine, in some ways, the liberty that judges should have and the autonomy that they should have to actually interpret the law, which I understand is their function. So it's a bit of a hypothetical because it may never come to pass.
Well, I think, in fact, it's not quite the question that we're dealing with. But I
think the jury, sorry, just to conclude with that, the jury then may well, if they are charged, then want to acquit the defendants. I mean, will we see a number of acquittals? That's really the question. Sorry.
So far, some of those cases have been criminal damage, which isn't a counter-terrorism case. There've been obstruction, which is also not counter-terrorism. So I'm not quite sure where your information is coming from on this, but it certainly hasn't happened yet. So we haven't had any
No, it hasn't happened
perverse
yet.
verdicts on that. So
No. Well,
thank
we
you.
could discuss this, I think, outside,
Yeah.
Yes, I mean, I think it's coming. That question is one that's currently being hotly contested in the courts, I know, and particularly the procedural situation where people are being kept in custody for longer and questioned under that legislation. I think it's very moot what will happen.
Yes.
Hi, do you think there's a real difference between perverse verdicts where there is no defence available in law on the agreed facts versus where the perverse verdict is said to be against the weight of the evidence? And should there be a difference in approach regarding the availability of an appeal?
For my
Konrad?
part, I do draw a distinction, in contrast, I think, to Peter. My feeling is that I was confining my remarks essentially to the ones where there's no dispute as to the facts, and the question is what legal conclusion is to be drawn from those facts. As regards verdicts which are against the weight of the evidence, judges differ, and they've changed their habits in the course of my lifetime. I have never had the slightest desire to push a jury into a particular direction, and I've been very happy not even to apply my own mind as to what I would find if it was my task to find that. I've never found that, but there certainly was a time when judges did try and push verdicts to juries, and if the juries didn't do it, judges were inclined to regard them as a perverse verdict. But my colleagues here have got far greater judicial experience in crime than I ever had.
Well, I took the same view, I have to say. I think that juries, if you push them, they tend to resent that and go the other way. So there's well, apart from the fact I don't think it's what the judge's role is. But in any event, most factual matters are capable of interpretation, and there must be many, many cases of judges across the country themselves thinking, I might have come to a different decision on those facts, but that's not the point. And you can usually see why the jury have come to the decision they have, even though it may be, on your view, against the weight of the evidence. Peter?
Yes, well, I think they are very few and far between, the real hardcore of perverse verdicts.
Yes.
That Konrad, I think probably we agree with, that it's very hard to justify how that can be maintained. It's just the methodology of how one would go about it with our rather curious jury system of resolving those perverse verdicts.
Thank you. Tracy?
I just want to be a bit controversial, if I may, because I'm surrounded by senior judges, some of whom are within kicking distance. But I just wanted to express an opinion and ask a question. That is, those of us who defend and have been at the mercy of the Attorney General's reference would like to know from the panel how the Court of Appeal is actually going to deal objectively with receiving this sort of appeal. I don't have confidence that it will be objective. I don't have confidence that the verdicts won't be overturned and go straight back to the Crown Court for a second trial. Is that fair? Is it right?
Are you talking about the situation which Konrad has described, which is effectively where there is a direction that there's no defence in law?
I'm talking about whatever mechanism. If the not guilty verdicts remain not final, how are they not final? Is it suggested that they're going to go to the Court of Appeal? And is that fair, given what the Court of Appeal do in relation to other things that they consider, particularly sentencing?
Yes.
I can't help on this. I'm out of touch as to what the Court of Appeal does, I'm afraid. Sorry.
I think if I was confining myself to the very clear perverse verdict where the legal position is black and white, and there's no arguably contestable factual scenario which doesn't place one fair and square within the prohibition of the law, then I'd be fairly confident of the Court of Appeal rightly deciding, well, this is one of those cases or it isn't. But I share some concern if it broadened itself to the sort of area that I was speaking more of, which is where there is a hue and outcry about a verdict which is unpopular from the majority, or is one which is politically, there's a political motivation for people to be convicted of what's happened. So I think I do have some concerns there, but no, I couldn't possibly say that the Court of Appeal wouldn't be objective.
Just in answer, Tracy, I think that one of the issues that we're discussing really is how political all of this is. You know, these are a small group of cases. Very rarely are they not involving some sort of politics involved, these perverse verdicts of this kind. And therefore, an appeal to the Court of Appeal, it seems to me, involves the Court of Appeal in really quite political decisions. And that's a question that we need to ask as well. Yes. Yes.
There's a risk that our society will move to extremist political positions with events in the streets becoming violent and serious crimes being committed to which there is no legal defence. But the composition of the jury may make conviction impossible for political reasons, because there will be a sufficient number of supporters of an extreme position. And I suppose I have in mind some of the things that happened before the Second World War in the east of London, for example. What's the panel's view on this? So far it's been perhaps rather tolerant, not least because societal damage, pointing perhaps apart, has been limited.
Konrad, any views on that?
I don't. I entirely understand the problem. I don't claim to have any access to a satisfactory answer.
In the in the scenario you speak of, I also have very great concern as to the make-up of the judiciary in that world that you speak of. And I suppose my natural reaction is that actually I'd be very keen to have a jury rather than a politically appointed judiciary finding for the ruling tyrannical party of the state. And I suppose my more close concern about that, it relates to some of the things I've read about issues in Hong Kong, where certainly my son's school, one of the schoolboys never came back because he'd been on a street protest and he was locked up, and I don't know what's happened to him. And so I think the strength of the jury is very important in the rather scary scenario you speak of that sort of world, and the size of a jury being one that I think gives some degree of confidence against problems. And actually, just to finish on, go back to a point that was raised earlier about the categorization of cases and perhaps withdrawing those from juries. I think I need to observe that there is a real fear among certain minority groups in society of having magistrates or smaller groups of judge and magistrates or judge alone determining some cases without a wider spread of a random collection of jurors. certainly in Bristol, speaking a lot, as I do, with groups of people who felt badly done by from minority ethnic groups, minority in Britain, not worldwide, that they're very anxious to have jury trial wherever they can, because they feel that there's a greater probability of their point of view being understood by 12 jurors than 3 magistrates or a district judge or whatever.
I think the point that you make, Geoffrey, of course, depends on whether, the jury selection remains random. If it does, then I think the point Peter makes is right, that it's unlikely that you're going to get a wholly homogeneous jury that entirely agrees with one point of view.
But isn't it sufficient to have a sufficient number to stop getting a guilty verdict when guilt is clear from all the evidence? If you have a minority extreme party,
it may be,
and you always get 4 of them on your 12-person jury, it might be easy for people to think they can get away with violence.
Well, I think you just have to look and see what happened. I think that, this is a problem, but there again, as I said at the outset, isn't it a question of whether society tolerates the odd perverse verdict, or has an appeal of the kind that Tracy, which is suggesting, would be bad for the defendants and rule of law, that it might put the Court of Appeal, if you like, in a very political position as well. Thank you. Any other questions? Yes.
Sorry to go again. It's all right, Jess.
No,
I do need to. Sorry.
Thank you.
We're now seeing quite large protests outside courts that are dealing with, for example, Just Stop Oil protesters or pro-Palestinian protesters, often being held in positions that are or seem deliberate so that juries do see them. And at times they can be quite intimidating, because we've moved past the sort of Trudy Warder style 1 or 2 people with placards into really quite large scale demonstrations. Do you think that those sort of external factors are a matter that, if we did have, for instance, appeals against perverse verdicts, should be taken into account? Or should, for instance, the Court of Appeal simply be looking at it as a straightforward, there was no defence, or it was against the weight of the evidence, without looking at external pressures that the jury might have felt?
Well, you might look at jury interference, which is a different issue altogether. But, from my point of view, it's a question of policing. It's a question of keeping, whilst being consistent with peaceful protest, people away from the courts themselves, further back, ensuring that jurors can come in without being interfered with.
I was going to say almost like a buffer zone, because it's a real problem now at Southwark, of the entire roadway just outside Southwark Crown Court.
Tell me
being
about it.
Entirely
It's not new, if I can put it that way.
And so would you give legal directions about that in those cases, irrespective of the position, to the jury, just to reassure them, or to ask them to bring to your attention particular problems they're facing?
I remember one case where we had to bus in a jury where there really was a intimidation, potentially, and giving a direction that they shouldn't treat that, obviously, as any way interfering with their decision, and that it was to ensure that they weren't, as it were, bothered, and they could be comfortable and reassured that they could come into what was essentially their workplace without anybody interfering with what their decision was going to be, and that if anything untoward occurred, then they should notify the court and that would be dealt with. And I think people do relax if you make proper arrangements to ensure that people can get in and out of courts effectively. It's relatively rare, but perhaps on the rise, I don't know. It's 2 years since I left. Yes, any further questions? Well, thank you very much. And thank you to our speakers. I'm sure that you've all enjoyed hearing what they had to say, and thank you very much for the very interesting questions that you've asked this evening. We will be continuing outside, and I hope that everybody will come and ask further questions.
On your behalf, may I thank Her Honour Deborah Taylor, His Honour Judge Blair and Sir Konrad Schiemann for this evening. It's pointed up for all of us the anomaly of the difference between the routes of appeal to the prosecution for the Magistrates' Court and the routes of appeal to the Crown Court, and in particular the way that anomaly may be increased if Brian Leveson recommends that we have an intermediate court with a judge and two magistrates who, again, I'm sure could be made to state a case. There's an apocryphal story, isn't there, told about the time Ken Dodd was prosecuted for tax evasion in the Liverpool Crown Court in 1989. Prosecuted, I might add, by Brian Leveson and defended by George Konrad. And the apocryphal story is that in the robing room, Brian Leveson said to George Konrad, well, the only question in this case is really whether a Liverpool jury will ever convict Ken Dodd. And why don't we just ask them that and then we can all go away? But he was acquitted, surprisingly. It's difficult for all of us because the cases in which we're likely to consider the question of perverse verdicts tend to be ones in which the emotions and in which the politics are engaged. And we've heard about that. We've heard the examples of the political suggestions that rape cases, for example, ought to be heard by judge alone or by one of these intermediate courts because there are too many what are thought to be perverse verdicts, verdicts against the weight of the evidence. There are thought to be ideas that protest cases should be heard. But the point, on the other hand, has been well illustrated by Judge Blair, is, of course, that that's the very heart of the matter. It's the matter where emotions and politics are concerned, that one wants to have a safety valve, the safety valve of the jury. And as Sir Konrad said, and as I'm sure we've all had, who've ever sat in the criminal court, there are many occasions in which the jury has saved us from doing things that we didn't want to have to do by way of sentencing. Even in my limited career as a recorder, I had a number of occasions when I was deeply grateful to the jury for saving me from that. So there's a balance, and I'm afraid there's no right answer to it. But we are all, thanks to our panel this evening, very much better informed about it, and we are very grateful. Thank you.